as a result of performing unnecessary and mutilating surgery on a very significant number of patients over a 13-year period. And he was prosecuted in 2017 and ultimately convicted. And I became really interested in this when one of his legal team got in touch with me about some work that I'd done with Professor Sarah Favard a few years ago on proper medical treatment and the medical exception. And it was particularly interesting because these two prosecutions of Ian Patterson and Simon Bramall, a knee surgeon, were the first time that any surgeon or indeed any doctor had been prosecuted in criminal law for non-fatal offences. And the only precedent was an Australian case. So for me, as someone who sort of works on the sort of intersection of criminal law and medical law, it was super fascinating. And that's because the background, traditionally, the only offence used to capture sort of medical wrongdoing and harmful medical activity that's similar at all is the offence of gross negligence manslaughter. And so what I wanted to do was have a look at how the criminal law and non-fatal offences could apply in cases like this. So I'm seeking to sort of develop the debate about the role of criminal law in healthcare. And this debate requires us to think about the way doctors and surgeons in particular are sort of regulated in the round. And I really like Dixon Wood's, Young and Bosk's conceptualization of a bad apple doctor. And they say that regulatory vulnerability in healthcare and medicine arises when bad apples fail to deliver on their professional obligations and betray the trust of patients and peers. And that's what we saw in the cases I'm going to discuss today, bad apple surgeons letting everybody down. So you can't see the bottom one, unfortunately, but the key question is, when should bad apples be prosecuted? So going back to the 1970s, this quote here by Glanville Williams really sort of characterises the regulatory approach to doctors. And he says controls exercised by the medical profession itself should be accepted as sufficient, and sees no role for the criminal law in regulating harmful medical conduct. And so, although now I think the medical profession is far more regulated than ever before, and certainly far more than it was in Glanville Williams' time, the law, and particularly the criminal law, continues to defer to the profession, especially in criminal matters. I'm sorry. There we go. So my focus really is exploring the sort of threshold for valid consent applied by the courts, and the related question, which is far more difficult actually to answer than the first, is what might be considered to be reasonable surgery. And I argue that the current law is unclear and anachronistic, and it perpetuates an approach that's inappropriately deferential to the profession. And this creates a dangerous space within which bad apple surgeons can abuse their surgical privilege. So the law that I'm going to be particularly looking at is the Offences Against the Person Act, and that should be 1861. I should have asked if anyone could spot the mistake. Oh, no, it's 1961 on my notes, but 1861 there, because I did realise I'm corrected. Phew. So these offences are under Section 20 and Section 18 of this very ancient law, in terms of wounding or inflicting grievous bodily harm with intent. And that's what Ian Patterson was convicted of. And then the other offence that was relevant in Simon Bramall, who is a liver transplant surgeon, was the offence of assault by beating, which is, otherwise known as kind of assault and battery within the criminal law. So these are sort of the least serious non-fatal offences. And in terms of the sort of legal principles, we find these in the common law in a series of cases, but the two most crucial ones, I suppose, are the case of R and Brown and Chatterton and Gerson. So R and Brown, as you lawyers will be aware, was a case involving a group of homosexual sadomasochists who had a sort of evening activity, and the activities came to the light of the police, and they were prosecuted for non-fatal offences. And their argument was, well, no, because we were consensually doing what our hobby is. And so therefore we should not be prosecuted. And this actually went to the European Court of Human Rights, where they lost again. But I mean, this is a very sort of contentious case with very sort of dubious moral underpinnings. But in this case, they identified a set of consensual harms that could be lawful. And one of these is reasonable surgery. So Lord Mustill and Brown said, many of the acts done by surgeons would be very serious crimes if done by anyone else, and yet the surgeons incur no liability. Proper medical treatment for which actual or deemed consent is a prerequisite is in a category of its own. So what my paper does is try and explore this category and sort of drill down into what reasonable surgery is. The other case, Chatterton and Gerson, again, lawyers will be aware that this is the civil case that really sort of determined sort of the low base for consent to medical treatment. And in this case, they said that information in broad terms about the nature and purpose of the procedure suffices for valid consent, thus avoiding a civil battery or criminal assault. So now I'm going to tell you a little bit about our bad apple surgeons. We've got a rogues gallery here. They look alarmingly similar, which is quite disturbing. But anyway, the first rogue is breast surgeon Ian Patterson, who mutilated, it's thought, hundreds, if not thousands of patients, mainly women, over a 13-year period working as a breast surgeon in the NHS and in private practice. So he was eventually arrested and prosecuted after many, many complaints to the police about the injuries that he had perpetrated. And so it went to trial in Nottingham Crown Court in 2017. And at the end of the case, before the jury went off to consider whether he was guilty or not guilty, the judge summed up and provided a route to verdict. And the first question in the route to verdict was, what was the advice provided by Ian Patterson to the patient so that they could consent to the surgery, such that no responsible doctor would provide? And if the answer to that question was yes, then they would go on to the second question. Obviously, if the answer to that question was no, then it would be not guilty. Second question was whether the accused knew that no responsible body of duly qualified and competent breast surgeons would have given that advice. Again, if the answer to that question had been no, he would have been acquitted. But if it was yes, there was a third question to determine in the trial. And so essentially he was convicted of 17 counts of GBH and 3 counts of section 20 wounding. And although now, I mean, in the sort of the aftermath of his conviction, you know, there were comparisons drawn between Ian Patterson and Harold Shipman, and people were saying he was a psychopath. But actually, during the trial, there was lots of evidence put forward by his defence team to show that he was actually a good doctor and a fantastic colleague. And so it was, you know, far from clear that he was going to be convicted until that verdict came through. Second bad apple pictured here is Simon Bramall. He is a liver transplant surgeon, because he retains his license to practice for now at least. And he was found guilty of assault by beating or assault and battery after it was discovered that he liked to brand the livers of his patients during surgery using an argon gas coagulator. And this came to light when one of the patients who'd received a liver rejected that liver, and so they had to remove it and pop a new one in, and they saw his initials SB, which they found rather alarming. And so there was an investigation in which colleagues testified against Bramwell, and it emerged that this was what he liked to do. And one of the theatre staff giving evidence said that she'd seen him doing this at one point in surgery, and she said, "What on earth are you doing?" And he said, "I do this," in a very sort of, you know, masterful way. So they just let him carry on until obviously he was discovered, and he pleaded guilty, and he was given a £10,000 fine and a community service order. And then he was hauled in front of the Medical Practice Tribunal Service, and they gave him just a 5-month suspension, which the GMC thought was too lenient, so they appealed that, and the High Court held that the Medical Practice Tribunal did not do enough to assess the case, and their 5-month suspension was insufficient to maintain public confidence in the profession and on proper standards and conduct for the profession. And so they have ordered a fresh tribunal with different members to reconsider that case. But there's a clear message that a 5-month suspension is not sufficient. So we've got these two cases, but they are, although they are the only surgeons who've actually been prosecuted and convicted in criminal law, that doesn't mean they are the only bad apples that we can see sort of, you know, a legal trail for, because the GMC also obviously deals with this type of problem. And I like this quote by Walsh and Chambers, who look at this kind of area and sort of failures in medical management and leadership. So, to anyone who is familiar with the litany of medical failures and scandals over the past 2 decades, these names and several others, the Patterson case will seem depressingly familiar. Once again, we see a charismatic, powerful doctor whose incompetence, misconduct, and criminal behaviour went unchecked for years in healthcare organisations where senior leaders knew what was going on but did not act. So 2 of those names are actually surgeons. Rodney Ledwood and Richard Neal were both gynecologists who were found by the GMC to have harmed many women. Neal had previously been convicted of manslaughter in Canada and struck off the Canadian medical register, but he was found to be fine to practice in the UK, and the GMC registered him on his arrival, whereupon he carried on his very harmful practice. And in the paper, I discussed other examples, including of non-therapeutic cosmetic surgery, which is a particularly dangerous area of medicine within commercial medicine. High rates of negligence with numerous cases of botched surgery emerge. And so, for example, one is Italian surgeon Arnaldo Paganelli was struck off by the GMC in 2020 for practicing without insurance after botched surgery left his victim with no redress. And we all know that cosmetic surgery in a private arena is big business. It's a rapidly growing industry that raises some serious ethical and public health questions. So we've looked at the cases, some other examples as well. What I then do is sort of try and examine a little bit more closely the legal principles about what reasonable surgery is. We know that consent is necessary but not sufficient, but we saw how in Patterson, the question of his criminal liability rested on whether he knew that his advice and the information provided at the point of consent was not responsible according to professional standards. If the jury had believed Patterson when he testified that he believed, albeit wrongly, that his advice was responsible, he would have been acquitted. And this suggests that consent is sufficient because the advice and by implication the surgery was not in fact objectively responsible or reasonable. So it appears that consent to objectively unreasonable surgery appears to be sufficient despite what the sort of headline legal principle suggests, provided the accused believed, however irresponsibly, that they were in fact acting responsibly. So, reasonable surgery. I mean, this is like the big question in the article, but does reasonable surgery have to be therapeutic surgery? And I think the clear answer to this is no, because non-therapeutic cosmetic private surgery is very often not therapeutic in the sort of traditional clinical sense. Penny Lewis has done some really brilliant work examining the medical exception in the criminal law, and she's identified 3 public policy justifications. So surgery should either be in the patient's benefit, for the patient's best interests, for the public, or for third-party benefits, such as if you donate a kidney to somebody during your life, or if you take part in some kind of, live medical research experiment, although normally they're not surgical. And then finally, there is a professional validation. And this third validation shows that when surgery is not in the patient's clinical best interest and there is no third party or public benefit, a surgical intervention may be deemed as proper medical treatment simply by virtue of professional involvement and acceptance. Brazier and Faval have also examined principles of proper medical treatment, concluding that professional power dominates again and again. So sort of search, I mean, part of my kind of, the exercise for this article was really kind of trawling around to find principles on reasonable surgery. You find little tiny bits in different places, but not a great deal. So in Bland, for example, it was said that therapeutic interventions are proper medical treatment. So by that, you might imply that if an intervention is not therapeutic, then it's not proper medical treatment. But clearly, that's not happening in practice. Other examples that are clearly not lawful and not reasonable are female genital mutilation. And so although that might be carried out by a surgeon in a surgical theatre, it's not regarded as surgery because it's regarded as a criminal act, it's mutilation. Another example of unlawful surgery is body modification performed by a layperson, and we saw this in a recent conviction of Brendan McCarthy, who appealed on principle to the Court of Appeal, arguing that consent should be a defence to harm done in surgical procedures involving body modification. And the court said that the appellant's argument envisages consent providing a defence whether or not that person is qualified and whether or not there is a medical, including psychological, justification for the surgery. But we know, don't we, that non-therapeutic cosmetic surgery doesn't need to have a clinical justification. And I really like this quote by Pitts Taylor, which describes sort of non-cosmetic surgery as a purchase characterised by the rhetoric of fashion, consumption and self-presentation rather than medical or psychological necessity. And there's lots of evidence to kind of support some of the more harmful and worrying aspects of this industry. The Keogh report back in 2013 and the more recent Nuffield Bioethics Council report. And there's a good article by Baker. He argues actually that certain cosmetic surgery should not be permitted at all just because they're too harmful and they can't be clinically justified. So, getting to the end now, everybody. The problem then, just to kind of summarize it, is that we've got contextually unsuitable and ethically unsound principles. Common law principles on consent to treatment are not sufficient to protect patient interests. And reasonable surgery basically means whatever surgeons deem to be reasonable. So we see that professional power dominates at the expense of respect for patient autonomy and bodily integrity. So I found Joel Feinberg's work really useful here, because in Harm to Others, he talks about the overlapping of wronging and harming, and how that can create a situation which is clearly morally unacceptable. So, for example, in the case of McCarthy, which, for those of you that don't know, involved somebody who wanted their ear removed, somebody else who wanted their nipple removed, and somebody else who wanted something done to their tongue, I can't remember what. In that case, the people that sought and received that treatment were arguably harmed, or they weren't wronged because they wanted those body modifications. Whether you agree with that is another matter, but that's what they wanted. Whereas with surgery, when victims of surgery are mutilated and seriously harmed, they have been harmed and wronged, because the harm that they suffered was not in their contemplation when they consented to the surgery. And we see other examples of a legal shift elsewhere in the law. And one, I think, quite useful example is in relation to sexual contagion, because consent to sex is no longer taken as consent to be infected with a sexually transmissible disease. Whereas it used to be, it was kind of like, well, you were up for that, so tough. The courts now take a far more sort of victim-centred approach to that question. And I think there's quite a good analogy between consent to surgery not involving consent to be seriously harmed, in comparison to consent to sex not involving consent to be harmed by a sexually transmitted disease. We see other examples in numerous places that I haven't got time to talk about. So my argument towards the end of the article is that we need to sort of pin down criminally unreasonable surgery more carefully. And I found Mason and McCall Smith's work on gross negligence manslaughter quite useful here. So they have looked at sort of medical mistakes that might be characterised as a simple error, or even quite a bad error, but not something that's really morally culpable, and not something that should therefore be of concern in the criminal law. And I think you could apply a similar set of a similar approach here. So a violation may be indicated when a patient suffers unexpected harm in circumstances suggesting there has been a violation. So, for example, if there is no consent to the surgery, as we saw with Ian Patterson when he told patients that they had cancer when in fact they did not have cancer. Secondly, if there is very seriously botched surgery coupled with reckless behaviour. And then finally, if there's a very serious error, which in clinical terms might be regarded as a never event. So this is something really serious, like taking the wrong organ or the wrong limb, or doing a wrong operation on the wrong patient. Currently, based on the principles applied in Patterson, only the first scenario would be an obvious case for criminal prosecution because there would be no consent. In the second two scenarios, consent may be present if the patient had been given honest information, no matter how sparse that information was, prior to surgery. However, in all three scenarios, the surgery would arguably not be reasonable, and thus, because consent to harm should only be possible for reasonably surgeries, all these might potentially, depending on the conduct of the accused, be a matter of criminal liability. Finally, so we see that uncertainty over the limits of the medical exception means that dangerous surgeons can be free to violate patients for far too long. In the article, I also suggest that guidance is needed for police, prosecutors and surgeons so they can understand when criminal liability should be considered. As was shown in Patterson, until a surgeon has accumulated many victims, is therefore obviously dangerous, police and prosecutors are understandably reluctant to become involved in what is usually a civil matter of compensation. But reasonable surgery should not simply be a question of what the medical profession deem reasonable followed by an assessment of the views and honesty of the accused. The flimsy principles available, which essentially borrow from Bolam, do not create a sound approach to determining whether a bad apple surgeon has departed from their professional obligation to do no harm in a way that is not reasonable and thus might be criminal. Moreover, the threshold for lawful consent, which requires only minimal honesty, is failing patience. So that's me done. Thank you very much. We're going to have a response now. First of all, from Lynn. Oliver first. Oh, yes, sorry. Sorry. Yeah, Oliver Quick is going to provide a response to that. So if we can get Oliver up on Zoom, that would be fantastic.
Thank you very much for that, Alex. That was really, really interesting. Just a quick introduction to Oliver before he does his response. Oliver is a reader in law at the University of Bristol, where he is also the co-director of the Centre of Health, Law and Society.
Fantastic. Good afternoon, everybody. And just to say, it's great to continue this seminar series. I thought last year went so well. And on behalf of everybody at Bristol, we're really, really chuffed to continue these sessions this year. Thanks to Alex. I really enjoyed your talk and also reading your paper. And congrats on the recent publication. I actually went old school and printed off your paper, sat in a comfy chair yesterday with a cup of tea and some biscuits. Probably should have had an apple, really, I guess. So thanks for that. It was nice to kind of sit down, relax and read the paper and think about it. Bad apple surgeons, clearly awful cases, terrible for victims and their families. And I guess the legal process inevitably exacerbates some of the harm caused there. Alex's paper clearly identifies the problems of applying principles of criminal law to cases of non-fatal medical harm. I could probably talk for the rest of the day. I think there are so many big issues raised here about bodily autonomy, the nature of harm, relationship between medicine and law, the aims and impact of criminal law, and how it relates to patient safety. But I'll limit myself to 3 questions to try and make this a reasonably quick, punchy response. First question, I think it's the big question, the general question is criminalization, i.e. going further than the existing law, desirable? Well, I'm not convinced. I mean, the Patterson case is clearly in criminal territory, but I think there's a large population of potential offenders out there, not just bad apples, some kind of less bad apples, some imperfect apples, perhaps some growing in poor conditions, so to speak. So I think that's my kind of one first concern is the extent of the population of potential suspects that the reforms that Alex argues for would apply to. I know in the published paper, you say you didn't have the space to fully discuss the aims of criminal law, but I'm not sure that we can totally avoid that. You note the 4 main aims of criminal law: retribution, deterrence, public protection, and rehabilitation. Arguably, you touched on this in your talk, obviously, retribution and public protection seem most obviously in play here. I wonder whether efforts to rehabilitate individuals like Ian Patterson would be taken seriously. Probably not, although we can think of cases, Hadiza Baragaba is a good example of a fatal case where she has been rehabilitated and returned to practice. Public protection, yeah, of course, but I did find myself nodding at that quote from Glanville Williams that you put up at the start, that there are other more effective and maybe appropriate ways of doing that. So, interim suspension of a practitioner, for example. I think deterrence is really interesting, not just deterring bad practice, which of course we want, but also the risk of potentially affecting good practice in terms of the defensive medicine thesis. I think in terms of deterring the bad, well, I doubt very much whether rotters like Patterson would be deterred by changing rules of criminal liability. I think it's unlikely they consult, the updates of Smith and Hogan on criminal law. So I'd be sort of suspicious as to whether any changes would be effective there and actually deterring real rotters like Patterson. But I'd also flag up the need to consider the impact on the good. So creating unnecessary fear and stress for those who probably wrongly, but would understandably worry about criminal prosecution. So adapting the well-known adage, I guess I'd wonder whether bad apples might make bad law, particularly that the rare, unusual cases might inappropriately shape the law, which of course applies mainly elsewhere. When you get a look at how medical cases have shaped manslaughter by gross negligence and the divide that's emerging there between medical and non-medical cases. And I know, Alex, you've written really well on the developments in that area. And I think, you can correct me if I'm wrong, but I think you agree with me that the appeal court, mainly one judge, Sir Brian Levison, too readily bought into the fears of the defensive medicine argument and changed the law as a consequence to that. However, as Alex points out, if we do have criminal liability for fatal harm, then why not for non-fatal harm? Well, I suppose my response is that we do. So cases like Patterson are proof of that, as are existing rules on consent by deception. I suppose my concern would be about the impact of widening the rules to make prosecutions easier, especially, and I suppose it's probably the most controversial aspect, it would be great to discuss this later on, this possibility of criminalizing a lack of informed consent. Because that's my first response. Is criminalization desirable? And I'm not convinced. Secondly, if it is desirable, then why just surgeons? So we know surgeons think they're special, but should they be special in the eyes of the criminal law? What about obstetricians? Okay, they are surgeons, but they would be possible suspects for this offence. Consider the facts of Montgomery. Indeed, Nadine Montgomery's consultant is arguably a good candidate for Alex's reformed offences that might apply here. What about less obvious examples? What about general practitioners who recklessly don't examine or refer deteriorating patients? So, missed and delayed diagnoses and the harm suffered as a consequence. Especially, negligent, reckless decisions not to physically examine patients during, the current COVID pandemic. And I suggest there's probably going to be a bit of a growth area for clinical negligence claims there against general practitioners. Now, that obviously looks and feels a lot less like criminal assault. Clearly no wounding or even any physical contact. And it is admittedly a stretch to bring that within even the reformed offence that Alex has set out, but that's not impossible. So I'd be interested again in Alex's thoughts on applying this argument beyond surgery. Of course, bodily harm is caused in lots of other ways. So inappropriate prescribing, maybe radiotherapy or chemotherapy that's deemed inappropriate or futile. That could also constitute bodily harm and potentially criminal activity under these proposals. Okay, then the third and final question I'd have is, and it's clearly the key question at the heart of this excellent paper, is how do we define reasonable surgery? Or indeed, if you go beyond surgeons, reasonable general practice, etc. Now, as Alex has said, clearly the original intention here was for this concept to consider whether procedures themselves are appropriate. So, limb amputations for those suffering from body dysmorphia, cosmetic surgery, female genital mutilation, arguably male circumcision. In other words, are they therapeutic or sufficiently therapeutic? I think it'd be remiss of me not to mention Peter Skeg at this point. So emeritus professor from the University of Otago, often called the master of medical law, although he's painfully modest, so we'd probably not like that description, but it's true. And I think he was the first scholar to analyze this question. And in short, his argument was that surgery was not criminally harmful if it aims to produce an overall benefit. Now, of course, assessing overall benefit is going to be contested, and I definitely agree with Alex that that shouldn't be assessed purely from the surgeon's perspective or the medic's perspective. Of course, in New Zealand, they've got a statutory defence of reasonable surgery in the Crimes Act, which talks about lawful purpose. But again, the same kind of issue as to what that means. What do we mean by lawful purpose? Reasonable surgery persists. Now, in terms of Alex's paper, the idea that reasonable might also encompass the quality of decision-making, so unreasonable decisions to operate, the technical quality of the surgery itself, bad outcomes, and also the quality of the consent process. Well, that's definitely different, perhaps quite radical. Now, in the paper, Alex limits this to two new situations. First, where surgery is a reckless decision in hindsight. And second, reckless mistakes, never events. I think there are officially 16 never events recognized by the NHS. And Alice gave the example of removing the wrong kidney or, foreign objects being retained in patients after operations. Well, that sounds fine, but I just wonder if it relies too much on a clear distinction between negligence and recklessness. When if we look upwards towards homicide and involuntary manslaughter, I think we can see that that distinction is not so clear cut and actually presents us with different problems. Okay, so on that final slide, and I think it's the closing comment in the paper, I think Alex says that whenever a patient suffers, so this would be the kind of ratio of the paper, I guess, this seems to be the kind of clinching line, whenever a patient suffers significant unexpected harm in circumstances suggesting that the surgeon has disregarded patient welfare, there should be greater scrutiny over how and why the harm occurred. Well, who can disagree with that? I think for me, greater scrutiny there must mean scrutiny by healthcare professionals, employers, specialist safety investigators, and also regulators. I'm less sure that the solution, or indeed that it would make much difference, if the basis of criminal liability was widened, and you'd expect that would lead to more prosecutions, but also, and perhaps my main concern, is the increased fear of prosecutions. I guess the final question to end with is, do we really want to criminalize lack of informed consent? That would apply to a lot of apples who are not all criminally bad. And I think we would need to be careful not to create a worried well of clinicians who'd fear criminal prosecution, and also the risk of reforming law, which generally applies in other contexts. Okay, I'll leave it there.
Thank you very much, Oliver. Alex, do you want to respond to this one now, or do you want to hear them both?
Well, Ollie's he's got to go, so I'll do a quick response.
Yeah.
I'm okay. I'm going to leave till 3 o'clock, so
okay, fine.
so I'll log back in as well when I have to leave. So hopefully I won't miss it.
Thanks, Oliver. that was I mean, I think you made some really powerful points there, actually. Yeah, I mean, in relation to is criminalisation desirable? I mean, I would say as a sort of, an overarching question, certainly not necessarily. And I just think there is a particular harm here. And in the paper, I do talk a little bit more about sort of private medicine, and particularly the cosmetic surgery industry, in terms of how, harmful surgery can be sold to vulnerable people seeking cosmetic enhancement who are perfectly healthy and well up until they walk into that cosmetic surgery practice, and so I suppose there's a sort of policy reason behind that, which links into some of the other work that I've done. So I would I totally see that point, but I think given that the very serious harm, because obviously the starting point for any involvement by the criminal law is always with the consequences. And so you would only really be obviously investigating a case if you had an example of a patient with, you know, quite a serious surgical injury, mutilation, or extremely severe, you know, harmful impacts upon their life. So this example, there was, you know, a group of women who weren't able to close their eyes anymore after they'd had cosmetic surgery, and there was a sort of William Hay called for public inquiry into that particular example. So it's that kind of very serious harm coupled with sort of, you know, the ethical vacuum that I'm particularly concerned about. I think, yeah, you're right to point out that, you know, well, if we're going to do this, why stop with surgery? Because there are lots of ways that doctors can harm patients. But suppose my particular interest was the way that those particular offences, particularly wounding and causing damage with intent, were applied in the Ian Patterson case. So, I mean, I would agree with you that there are probably just as sort of harmful examples within other areas of medicine where nobody ever picks up a scalpel. But, and you know, I wouldn't necessarily want to see sort of, you know, broader criminalisation of healthcare and medicine in general. It's the sort of specific surgical issue that I was more concerned about. And I did actually, I mean, this, for those of you who are sort of, you know, struggling with trying to get, you know, work published, this sort of sorry tale of this paper is that one version of this did have a big section about the aims of the criminal law, but then one of the reviewers said, no, actually, don't like that, blah, blah, you know, as reviewers do, bless them. So that went out, but I agree, you know, I think you could write another paper on the way that that this type of application of the criminal law, and indeed others, and lots of people have written about gross negligence and manslaughter, about the extent to which gross negligence should or should not be criminalised. Yeah, I mean, again, you know, I can't disagree with you that this would lead to increased fear of prosecution in the profession. But I mean, the point I make in the paper is that, you know, surgeons ought to be educated about this. And, you know, it's only really going to apply for, you know, really heinous examples of surgical misconduct. So, but again, I mean, that hasn't prevented, you know, widespread fear about other legal consequences, particularly gross negligence, manslaughter. But there is, you know, I suppose there's a bit of a difference there, because any doctor at any point in time could make an error that could lead to the death of a patient. Whereas in surgery, it's a specific decision to go ahead with a very harmful intervention. So I think there is a distinction there that again, I don't draw that out in my paper, but I think you certainly could do. But yeah, talk all day about this. Thank you very much, Oliver.
Oh, you're welcome. I think definitely scope for another paper there, isn't there, on that kind of looking at the aims of the criminal law, and particularly thinking about beyond surgery. I think that would be, as you say, that's kind of another paper in itself.
Yeah, definitely. Thank you. So we've got Lynn next for a response, I think, and then we'll open it up to questions for everybody. So I'll sit down again.
One of the questions I was looking to ask has been asked and answered there, and again, it's about what is reasonable, who decides, and what is the benchmark. And obviously, Alex has spoken about it, whatever the surgeons deem to be reasonable, and how, you know, this is in conflict with patient rights, especially a lot of the stuff that's come through since Montgomery. So I think that's pretty much been answered. And again, on that theme, I was going to speak about non-therapeutic amputations as well, and the case of Robert Smith in Falkirk at the beginning of 2000. So yeah, I found that really interesting. What also seems to come through, looking at the Glanville Williams quote, the controls exercised by the medical profession itself should be accepted as sufficient. But it seems here that, particularly in the cases that have been mentioned, as well as, you know, some that have flown under the radar, that these controls are not sufficient to prevent patient harm. And in order to protect patients, do we have to start looking at how the medical profession censors itself? Do we need external scrutiny beyond that? Especially, you know, thinking about Bolam and how that deference to the medical profession almost looks like it could infringe parts of like the rule of law to an extent, that doctors and particularly surgeons see themselves as above others. Another thing I thought was particularly interesting is these doctors have been described by Walsh and colleagues as charismatic and excluding professional arrogance. And particularly the Bramwell case comes across that he was in a culture of bullying and domineering towards other staff. And would resort to criminal law change this culture and stop, you know, surgeons thinking they can get away with things just because they do it, which is really quite frightening. So how could this change such a bullying culture where someone tries to blow the whistle or tries to speak up and they're shot down even though they know it's wrong? I think a final thing I would say is the discussion you have on page 19 about Feinberg's consent as legitimising principles, and how those who consent to surgery because they need it and they're so desperate at that point, is this valid consent? And does this legitimise it as a reasonable form of surgery if they have become so vulnerable? Apart from that, that was a really, really interesting area to look at, and I do feel now a little bit scared of these kind of situations. I don't know if anybody else feels that way too.
Thank you very much, Lynn. And I should have said before Lynn started, Lynn is doing a PhD at the University of Edinburgh, looking at the relationship between medical futility, best interests and experimental treatment, and has previously worked for the NHS before that. So put a bit of context to Lynn.
Thanks very much, Lynn. Yeah, I mean, I think, again, as Oliver picked up on something that I sadly had to cut out of the paper, that issue about the culture and the sort of hierarchical bullying, you know, working environments. I mean, there's a number, if anybody's interested, there's a number of inquiries into Patterson. There's one done by the NHS just where I worked for 13 years, another one in the private hospital, and then a government-led one. And these really sort of shine a light on this kind of really awful culture. And I think there's a particular problem in surgery where you tend to get these sort of older men who are, you know, have a tendency to sort of override any attempts to control what they do. And you know, there's definitely, you know, more research that is needed in that area, because I think that was one of the main reasons, certainly why Patterson was permitted to carry on for as long as he did, when everybody knew that he was harming patients. They knew that he was carrying out discredited procedures. At one point, they told him to stop with the partial mastectomies, but he completely ignored them and just carried on anyway. And they, you know, this was just allowed to happen for years and years and years. So thank you very much and good luck with your PhD, Lynn.
Thank you.
So I think we can open up to any other questions.
Yeah, I'm just going to stop the recording now just so that